Hello, respected viewers. So, welcome back to English Law. So, this is a talk about contract law and European Union law. So, there's still a lot of EU legislation which is on the statute book in the United Kingdom, obviously, particularly looking at England and Wales. So, European directives were transposed into national law. It was up to each member state to meet a certain standard by a deadline, and they could do so in their own way. So there was a European Directive on Unfair Terms in Consumer Contracts, 1993. And so this was put into UK law, in some cases, just word for word from the directive. But the Unfair Terms and Consumer Contracts Regulations, 1994, that was the UK transferring this into domestic law. Okay, so on the regulations there a lot of it was about good faith. So it was tricky, though, understanding how to transpose somewhat Roman law measures into a common law system. So the Law Commission of England, Wales and Scotland suggested new legislation. So the 1999 regulations came along, and that really updated extant UK legislation, such as the Unfair Contract Terms Act 1977. So it was a sort of tidying up exercise. Anyway, so there's a Consumer Rights Act 2015, and Part 2 of the same revoked bits of the 1999 regulations and the Unfair Contract Terms Act 1977, inasmuch as these were applicable between business and consumers, B2C, business to consumer contracts. If that sounds nebulous, well, it is. Anyway. So the provisions of the Unfair Contract Terms Act 1977 is still applicable to business contracts. Anyway, so the European Directive on Unfair Terms and Consumer Contracts is a very complicated issue, and it's illustrative of a broader challenge dealing with EU legislation, because of the different ways that Roman and common law systems have approached this, particularly with regard to statutory interpretation. So